we have like regular lights we could also put on? Yeah. Great. Hello. Hi, everybody.
Hello, AG. Thank you for rushing back here and doing this for everyone.
Yeah. I hear the audio didn't work. Is that correct?
It's been a joyous Wednesday for reporters. So we appreciate that you're fitting this in, and we have more folks.
And the important thing to know is that I was amazing, since you'll have no opportunity to corroborate that.
We will start with Christy. Christy, if you're there, you've got your hand up, you can ask the question.
Okay, can you hear me now?
Yep.
Okay, well, since I didn't hear the argument, what do you hope to come out of this hearing today?
Well, obviously, you know, our hope is that the court will find that within the word sex, as it appears in Elliott-Larsen, that, you know, LGBT people will be included. Our argument today centered on sexual orientation. It's not clear whether or not they'll consider gender identity. There was a favorable ruling, a couple of favorable rulings based on gender identity already in other cases. But this is the first time that, frankly, either of those matters have been before the Michigan Supreme Court. And in fact, the case that you know, was considered to be stare decisis in this case in this matter for so many years was a Court of Appeals decision from 1993, the Barber decision. So the Supreme Court has never actually issued a ruling on this matter, and so we think it's long overdue. And we think it's time for the hundreds of thousands of people who identify as LGBT who live in this state finally are entitled to equal protection and equal treatment under the law.
Thank you.
Jonathan?
Yeah, Attorney General, apologies if my signal is noisy, but can you reiterate why you thought it was important to argue this case yourself?
Well, there were a number of different reasons. First of all, as many of you know, I've practiced in the area of LGBT rights for many years. And, you know, it really struck me right after the Obergefell decision came down, which, as you know, Michigan was a big part of, because people were getting married immediately that weekend. The case came down on a Friday morning. And for a lot of people who have been married out of state, there was automatically reciprocity. So their marriages sprang to life and became legal in Michigan. And then a lot of people just went and got married over the weekend. And many of those people called me on Monday morning because they walked into work and they tried to, you know, register their newly recognized spouse and sign them up for healthcare benefits, and they got fired on the spot. And, you know, I was so happy, of course, about having won the marriage equality case, but it made me realize that we still had a long way to go, and that it was incredibly important that the law be changed so that whether it's in employment or housing or education or public accommodations, that we don't have this substantial number of people who live in our state, who call Michigan home, be discriminated by its laws. And the purpose, the intent of the Elliott-Larsen Civil Rights Act, I mean, it's something to be very proud of. It was a broad and remedial, forward-thinking statute that was intended to include as many people as possible. And so we're hoping that when this decision comes down, it's going to include a whole lot more people under its protection than currently exists.
Thanks. And if I could, just a quick follow-up. I'm one of those reporters who didn't hear the oral arguments yet. So, you know, oftentimes there are certain, you know, questions from justices, et cetera, that might, you know, make you, I don't know, I guess, did you pick up anything from the justices that sort of was encouraging from your perspective?
I thought a lot of the questions were encouraging. I thought the most interesting question, I thought, didn't go to me. It went to John Birch, who was arguing on behalf of the ADL, and it was from Justice Zara. And he talked about the fact that for so many years, time and time again, John Birch has come into the court and argued for strict textualism, a strict interpretation of the language. And today he was doing sort of the opposite. The argument that was being made is to look at all kinds of things outside of the text that involve, not just legislative history, but the lack of legislative history, what later legislators did or did not do in terms of amending the law, and somehow to take what other legislatures did or didn't do and impute that onto the 1976 legislature. And, even Justice Zara, I thought, was really questioning, the contradiction in the arguments he had heard from this one attorney over the course of many years, because of course he's a former Solicitor General under Bill Schuette. And so that was encouraging to me, because our argument was a, plain text argument that the word sex, while it's not defined under the Elliott-Larsen Civil Rights Act, that it's meant to be read broadly. And so we know all kinds of things are read into that, whether it's sexual stereotyping or whether, it's a variety of other types of legal terms and phrases that we read into the word sex, that it's time that sexual orientation, and I would argue gender identity as well, is read into the word sex. Because let's face it, in the case of our complainants in this case, we have women named Natalie and Megan who tried to get married at this venue at Rouch World, and they turned them down. They said, we think sex is only between a man and a woman. And the fact is, if you were to swap out Megan for Matt, or swap out, Natalie for Nate, they would not have been discriminated against. So it's just clear cut. It's discrimination against sex. Sex and sexual orientation are inextricably linked. You can never know a person's sexual orientation without first knowing their sex. And so it's as easy as that. And my impression was that the justices understood that. And I can never predict anything, but I'm cautiously optimistic that the court will rule in our favor.
Charlie?
Thank you. Good to see you. I also did not hear the arguments, but I can't wait to hear them. But my question is, I don't know if the argument was made, but Attorney General, do you maybe blame the legislature for not clarifying what the law should be? And is that an argument that maybe the court shouldn't clarify what sex means? It should be the legislature.
Well, the way that statutory interpretation works, Charlie, is that you're supposed to look at the plain language of the law. And if it's clear and unambiguous, as we argue this is, you're not supposed to try to divine what each and every legislator who voted, or for later legislatures who didn't vote on it, would have thought that law would have meant. How many times have you talked to a legislator and you said, can you tell me why you voted for this law? And it's clear that, it's a different reason than you would have thought of. Or let's face it, sometimes, especially during lame duck, I didn't have time to read the bill. I didn't even read it. So it's really hard to say, well, this is what the legislature must have meant when they passed this law. We look at their words, and we believe that the legislature speaks through its language, and it means what they mean what they say, and they say what they meant. And what they said here is sex. And again, sex includes sexual orientation and gender identity.
Justin?
Can you talk about some of the counter arguments that you're hearing to this? Obviously, you said hope or cautiously optimistic about things ruling in your favor. What are some of the arguments you're hearing against it? And do you believe that they have any merit?
Well, the primary arguments that were made was that, they didn't expressly define sex as sexual orientation. And that's not what the legislature intended. But I would say a few things. One, in terms of what the intent was, the intent was clear when ELCRA was passed, and it was to protect people who were either, women or people who were in the minority who had been subject to discrimination. But the thing is, there's a difference between unanticipated consequences and unexpected consequences. We later on, right, that this was not a law that was designed to protect white men. The predominantly white male legislature in 1976 didn't say, oh my God, we need a law that'll better protect white men. But the fact is, Elliott-Larsen also protects white men, right? We see reverse discrimination lawsuits all the time. Even if that was not something they initially intended, it was encapsulated within the law. And that's the same thing when it comes to sexual orientation and gender identity. It's such an easy test. All you have to do is substitute the person you're talking about. You know, if it's a man, you substitute them with a woman. If it's a woman, you substitute them with a man. And if so, then it's easy. That's sex discrimination. And then that goes for gender identity too, right? If you would accept, for instance, if we don't have discrimination, we're not permitted to discriminate against people based on religion, right? So if you allow a Christian to be employed by your company and you allow a Jewish person to be employed by your company, you can't say, well, I don't like that you converted. I don't like that you're a Christian who became a Jew or a Jew became a Christian. Same thing with men and women. We can't say, well, we hire men, we hire women, but we don't hire men who become women, because it's just plain sex discrimination. And same thing with sexual orientation. If the thing that we are discriminating against is, you know, you are a woman and we think you should be married to a man, but you're married instead to another woman, that is sex discrimination. Because again, if it'd been a man who was married to a woman, if you accept a trait or a characteristic in one gender, but not another, it's classic sex discrimination. And that's what we argued. And we think that'll be a successful argument.
Christy, did you have a follow-up? This will be our last question.
I'm all set.
Okay, great. AG, did you have any other final thoughts?
I would just say this, you know, it has been 46 very long years since Elliott-Larsen was passed. And we are a better state and a stronger state when everybody is included under the protection of the law. And I really hope that at long last, that's what we see happen. We know that Michigan does better, not just from a civil rights perspective, but from an economic perspective, when we include everybody under our laws. And I hope at long last, that's what we'll see happen when the court comes down with their decision later this year.